welcome you to this special presentation on immigration, just the facts. And we will hear from a very talented attorney who I have the pleasure of knowing, have had the pleasure of working with for many years from our time in Indianapolis, Angela Adams. Let me tell you a little bit about Angela. Angela is the owner and managing attorney at her own legal firm, at Adams Immigration Law. Prior to that, she's worked in other law practices, primarily at Lewis and Kappas, but then also served as Associate General Counsel for Immigration at Indiana University for 3 years. Angela has a big heart, and she brings that to her very fine expertise in immigration law, and so she's a very compassionate lawyer who works with people in the community, and that has also led her to be in boards of directors of places that care about immigrants and immigration. Most notably, she has been a board member and past president of the Immigrant Welcome Center in Indianapolis. She's a current board member of Su Casa Columbus, and she's a board member and past chair of the Mexican Scholarship Fund in Indianapolis. She's a talented attorney that knows a great deal about the issues that we face today, and she's going to share with you her knowledge, and then she's going to have an opportunity for us to ask questions. If you didn't get a card as you were coming in, make sure you flag down one of our church members or ushers so that you can write a question down. And then when she's done with her presentation, we'll both take a seat. I'll take the questions and I'll start giving her the questions and she will answer. We will honor your time. We will be here no later than 8 o'clock, but if you feel the need to leave after some time in the question, you're welcome to do that. Again, welcome, and welcome, Angela. Grateful that you're here.
Testing. Yep. Testing. Working? All right, good. Okay, so thank you so much for having me here. Thank you, Felipe, my dear friend of many years. We used to work together in Indianapolis. We missed him a great deal, but you guys are so lucky to have him here. This is a beautiful church, my first time here, so thank you for the invitation. Great turnout. Thank you for coming out tonight. So, I want to talk to you about immigration, just the facts. I want to preface this by saying that I try really, really hard not to give you my opinion. I try to leave my opinion at the door, because I think if you know the facts and if you hear the current state of affairs from a factual perspective and from my experience as an immigration attorney, you can draw your own conclusions and you can have your own opinions, right? So I'm not here to tell you what I think, but I'm here to share with you my experiences and the state of affairs today. So, just the facts, current immigration law and the uncertain future. No, it's not on that side. So can you all see that over there a little bit? Yeah? Okay, good, okay. So, we're going to talk about existing immigration law, an overview, brief overview. I promise I won't make it too difficult. Your head might hurt just a little bit, but we'll try to make it easy. Then why can't undocumented immigrants just get legal? This is something that has always been a part of my presentation because people ask me this question all the time. For the last 20 years, since I've been working in the community and visiting Columbus, Indiana, back when I worked for the Indiana Department of Education with Migrant Education Program and used to visit your schools in Bartholomew County, people would ask me this question: why can't they just get legal? And not much has changed, unfortunately, in those 20 years. So we're going to talk about that. And then executive orders. What are the executive orders? What do they mean? What are the current enforcement priorities? And then impact on the workforce, because in Columbus, you've got quite the strong manufacturing industry here and lack of workers to fill those jobs. So, non-immigrant visa categories. So these are, if you're a non-immigrant is coming here for a specified purpose for a period of time with an end date. So they come here to work or to visit or to study, something along those lines, but it's temporary, okay? There's an end date and they have what's called non-immigrant intent. The intent to leave at the conclusion of that period of time, okay? So here are some examples. You've got visitor visas. The B2 visa is the most common, someone coming to visit the United States for a 6-month period, and then at the conclusion, they're going to leave after that visitor period has ended. Work visas. You may have heard the most common work visa is the H-1B visa. The H-1B visa is commonly used by industries like Cummins, for example. H-1Bs are for a position that requires a minimum of a bachelor's degree, and the person has the bachelor's degree. So it is not for a factory worker, a low-skilled job. It is for a professional bachelor's degree minimum in the H-1B. There's something called the H-2A for agricultural workers, or the H-2B for temporary seasonal workers. Those are very, very difficult to get and oftentimes don't coincide. If you're in agriculture, may not coincide with the dates that you need someone. Like you need someone for the harvest, you may not be guaranteed that you're going to get someone on time to get your crops picked. So, other work visas. L is for an intercompany transferee, someone who's got a company abroad coming to the United States to work for the same company here, for an affiliate. An E is for an investor visa or treaty trader, somebody who's investing in the United States pursuant to a treaty that we have with that country. O and P are for athletes, artists, and entertainers of extraordinary ability or coming to work in a cultural kind of piece or workshop. I've never seen a Q, that's another cultural exchange. R visas are for religious workers, someone coming to work for the church as either a minister or someone in a traditional religious occupation, okay? Government visas, someone coming like to work for a consulate, for example, like the Mexican consulate, may come here on the A or the G visa. Student visas, you've heard of probably the F visa, student visa, that's the most common, or J is the other most common, student visa. OPT is the period of time that they get after they finish their degree to work in their industry or their career for some practical experience, optional practical training, OPT. So they can work up to 1 year in their field of study. If you're STEM, science, technology, engineering, mathematics, you could be eligible for an additional 2-year extension on the OPT. TN is through NAFTA for Canada and Mexico for specific occupations, professional occupations, not all, and only for Canada and Mexico. ST and U are for victims of domestic violence or violent crimes. T visa is for victims of human trafficking. A U visa, which is fairly common if you've been the victim of a crime, violent crime, and you've suffered harm, and you will be helpful to the prosecution or the investigation of that crime, then you can apply for a U visa. If you can get certification from local law enforcement or the prosecutor's office that you have been helpful. So you can't just apply for a U visa, you actually have to be actively doing something to help them. K visas are for fiancé visas, someone coming to the United States to marry a US citizen. So anything missing on this list, this alphabet soup? Anybody? Anything missing? There's one thing I think is pretty clearly missing are the labor positions. So there's nothing on there for factory workers. There's nothing on there for frontline. There's nothing on there for, you know, those type of positions that may not require a bachelor's degree. It may be a vocational or some kind of trade. That's not on the list, okay? So keep that in mind. So if you're not a non-immigrant, you might be an immigrant. An immigrant is somebody with immigrant intent, which means they're coming to the United States to stay, come to work, come to stay, come to live permanently, usually based upon either employment relationship or a family relationship, okay? So people hear all the time, how many of you've heard the slang term green card, right? Yeah, most people have, green card. I still call it a green card. I don't even know if it's green anymore. I think parts of it are green, parts of it are pink. Okay, so green card is the slang for lawful permanent resident, LPR we call it. Lawful permanent resident is the thing that you get if you apply for permanent residency for adjustment of status to stay in the United States. A lot of people don't know that you don't just become a US citizen. So US citizen is something that happens later, once you've been a permanent resident or a green card holder for at least 3 or 5 years, depending on how you got it. So people say, you know, I've heard, well, can't they just go get their US citizenship? Well, they're married to a US citizen, so doesn't that automatically make them a US citizen? The answer is no. You have to go through the application process, and you have to apply, and you have to be eligible and go through all, we'll talk about that too, and become a permanent resident before you can be eligible to go through a process called, and at the very end here, naturalization to become a US citizen, which requires speaking English, passing a civics test, and some background checks and things like that. So the most common way to get a green card is through either immediate relative, a family-based preference category, or an employment-based preference category. I'll explain that more in a minute. People ask me too, well, I just need a work permit. Can't you just get me a work permit? I just want to work, that's all. I don't even want to stay here. I just want to work. The answer is no. You can't just get employment authorization. Employment authorization is an ancillary benefit to a pending adjustment application. So like, you're gonna become a permanent resident, you have an application for a green card pending, you might be eligible while you're waiting to get an employment authorization document, okay? But you can't just go get an employment authorization card by itself, okay? There is no way to do that unless you qualify. The other one on here is asylee or refugee. And asylee or refugee is on the immigrant visa category because asylees and refugees are lawfully present immigrants in the United States. Let me tell you the difference. An asylee is already here in the United States. They've come on a non-immigrant visa, somehow they've entered, and they are applying for asylum in the United States based on well-founded fear, past persecution or well-founded fear of future persecution on the basis of one of the 5 grounds: political opinion, social group, nationality, religion, what's the last one? I think, no, is it gender? I don't think gender is a basis. Anyway, what is it? What's the other one? Oh my God, 5 grounds. Okay, so now, if you're applying for asylum based on political opinion, for example, you have to prove that you've been the victim of persecution by the government or a group that the government is unable or unwilling to control in your country, okay? So we're not talking about here. We're talking about the person comes from their country, they have to prove they've been persecuted, or they have a well-founded fear of persecution, okay? And that they haven't been a persecutor, they haven't persecuted anyone else on those grounds. A refugee is someone who's coming, already have been deemed a refugee outside of the United States and vetted by at least 5 different federal and international organizations, the United Nations Commission for the UNHCR, United Nations High Commission on Refugees, and then they're resettled in the United States. We have 2 places in Indiana where we resettle, Fort Wayne and Indianapolis right now. Bloomington was trying, but then everything with the refugee situation has changed. They're not resettling as many refugees as they were before. They used to settle upwards of 50,000. and then maybe even more. Now we haven't even resettled half that amount. And so places like Exodus and Catholic Charities have had to let go about half of their staff because they're simply not resettling the numbers of cases that they once were. You may be familiar with, on the south side of Indianapolis, we've got quite the Burmese population. That was a large refugee population. So they're no longer coming like they were, but they come, when they enter the United States, they come lawfully. They are here, and by virtue of being a refugee, they can live and work in the United States permanently. They are here. So they are lawfully present, they're able to work, all of those things. So that's a refugee. Okay, so if you're not an immigrant or a non-immigrant, you might be undocumented, okay? Undocumented, people ask me all the time, well, which word do you prefer to use? Undocumented, illegal, unlawful, what do you prefer? I prefer the term undocumented because the term illegal seems to connote some criminal intent, and I can tell you that the simple act of being present in the United States without authorization is not in and of itself a criminal violation. That is not a crime. The act of coming across the United States border, or coming once or twice or more than once, may be a misdemeanor or a federal offense. But if you're sitting next to me today and you're undocumented, just being here undocumented is not in and of itself a crime. So that's why we say undocumented. People say different things. So there are two types of undocumented immigrants. Overstay, someone who came on one of those non-immigrant visas. Remember those non-immigrant visas that we talked about? They came on one of those and they didn't leave. They stayed after that expiration date, okay? They didn't leave. The other type of undocumented immigrant is someone who may have entered the country without inspection. In my field, we call that EWI, EWI. So if you hear me say EWI, now you've all learned, what is EWI? Entry without inspection. What does that mean? What does that mean? Entry without inspection. They crossed the border without documents. They didn't go through a port of entry. They were not inspected or paroled. They did not come in contact with any immigration official. They came without papers, okay? So that's, in my world, that's the legal phrase that we use. So those are your undocumented immigrants. So if you're an immediate relative of a US citizen, what's an immediate relative? It is a spouse, parent, or child of a US citizen. Nothing more. No grandparents, no aunts and uncles, no cousins, no distant second cousins, none of that. So if you're an immediate relative, for example, spouse, okay, a spouse of a US citizen, the only way you can fix your status in the United States is if you are an overstay. Remember, we just heard what overstay is? So if you're EWI, you entered without inspection, you are not eligible to fix your status in the United States under the current law. Okay? Is that understandable? If you entered without inspection, you cannot fix your status, even if you have an immediate relative that is a US citizen. Even if you marry a US citizen, you would have to leave the country and go fix it at the consulate abroad, okay? So an immediate relative, a couple things here. Immediate relative, again, is defined as a spouse, parent, or child. Child is under 21, okay? And people ask me all the time, well, what if they have US citizen parents? Can't the parents fix, or I'm sorry, what if they have US citizen children, but the parents are undocumented? Can't the kids help the parents fix their status? And the answer is no, because you have to be over 21 in order to petition for a parent. So a child, by immigration definition, is under 21, 21 and under, okay? So you can't petition for your parent unless you are over 21, and only if you are an overstay. Only if the parent is an overstay can they fix their status in the United States. So I'm gonna bring up some hot button terms, okay? And I'm not trying to offend anyone. I'm just gonna bring them out and we're gonna talk about them. So have you heard the term anchor baby? Okay, anchor baby, what is that? Someone comes to the United States to have a baby so that they can stay as an anchor? Well, so taking all of this into consideration, that is about maybe 1/4 of the time true. Because can the baby help the mom get legal status? No. Not until the baby is 21, and only if mom is an overstay. What if mom's EWI? Can't do it. Can't do it. So that's why I'm telling you it's legally impossible. In my world, I have to say, I'm sorry, there's nothing I can do to help you. Until or unless the law changes, okay? So you might be thinking, well, can't they just leave the country and come back and do it the right way? Can't they just leave the country and come back and do it the right way? Well, maybe, but if you're EWI, first, you know you can't adjust your status in the United States, but guess what? There's something called the 3 and 10-year bar. Are you listening? If you've been here in the United States for over 180 days without status, and you leave the country, you will trigger a 3-year bar. If you've been here for over a year without status and you leave the country, you will trigger a 10-year bar. Okay? So mom has a child becomes 21, mom's EWI. Can mom just simply leave the country to get her visa and come right back? No, absolutely not. Mom will be subject to what? 10-year bar, okay? There's no waiver because the child is not a qualifying family relative for a waiver. Waiver can only be sought if you've got a parent or a spouse that's a U.S. citizen or a permanent resident that would suffer extreme hardship if you are not able to come back to the United States. Those cases are about this thick when they come out of my office, and they cost a lot of money to prepare. So that's not not just financial, it's not just, oh my God, I'm gonna miss my husband. That's not it. It's major, financial, education, job, all that stuff. So you've got the 10-year bar. So have you ever heard someone say, just get in line, just go back, get in line, or go back and come back the right way? Go back and come back the right way. Is that possible? In many cases, legally impossible, okay? Legally impossible. So I'm asking a rhetorical question. You don't have to answer this. What would you do? Just think. You don't have to answer. He fell for it. Okay, so seriously, what would you do? I don't know because I'm not in that situation. I try not to judge people because I don't know what they're going through. I don't know their personal circumstances, where they came from, why they came in the first place, what family members they have. I have no idea what someone is going through. So for me to judge, that's hard. I can't do that. But I can say, you know, if that were me, I'm not sure what I would do. You can't stay and fix it, and you can't go and fix it. You're stuck. And you may have been here for many, many years, or your children have never been back, or, you know, the list goes on and on. So there's a conundrum there. There's a catch-22, whatever you want to call it, it's there. It prevents people from leaving because they can't fix it and they can't come back. So they're gonna make those decisions. Now, this is interesting, 9C, 212A 9C. So let's say someone marries a US citizen. They entered the United States one time illegally, so they're an EWI. They stayed for a little while, they married, they left the United States to go to their father's funeral or something, and then they came back a second time without inspection. Guess what? 9C is what we call it, 9C because that's the law. 9C says no waiver, none. You're stuck. You can't even ask for a waiver, even if you're married to a U.S. citizen, even if you have U.S. citizen children. So that person cannot fix their status ever unless they go to Mexico or wherever they're from and stay for 10 years. Then they might be able to come back, apply to come back. Unless you're 245I. What's 245I? Does anyone remember back in 2001, April of 2001, in the Bush administration? You remember any kind of immigration reform? Probably not. You didn't really hear about it then. So 3 times we had this law called 245I. In the 90s and then in 2001, they said, okay, we know we have an issue with the 3 and 10 year bar. If you have an employer that's willing to sponsor you, or you have a family member that's willing to sponsor you, we won't make you leave the country and be subject to the bar. We'll let you, by paying a fine, doing all these things, proving your physical presence, you can get an exemption from that, and we'll let you apply here. That's called 245I. That was the last real substantive immigration policy change, I would say, that actually facilitated applications going through. And that was under a Republican president. And prior to that, but then, so guess what happened? April 2001, what happened right after that? 9/11. So Congress was in talk to extend that again, and then everything went out. It was off the table. So, very rarely we'll get somebody walking in our office that had a case filed before April 30th of 2001, and we'll be jumping up and down because 245I applies, and they might be grandfathered. Doesn't happen very often anymore. Family-based preference categories. If you're not an immediate relative, you might be in a family-based preference category. These are the family-based preference category. First is unmarried sons and daughters of U.S. citizens. Second, spouses and children. Unmarried sons and daughters of permanent residents. You know what that is now. Third, married sons and daughters of U.S. citizens over 21. Fourth, brothers and sisters of adult citizens. Okay? These are the only preference categories. Okay, another emotionally charged debate. Chain migration. Have you heard of that? New, non-legal term? Because that's not a legal term. It's like a PR term, right? Some of these PR terms, they make people on the right mad, they make people on the left mad. They make everybody mad. Okay, so chain migration. This is what they're talking about. But they're not giving you the whole story. This does not include grandparents, aunts and uncles, cousins, whatever, all of these distant relatives. You can bring all your distant relatives. That's not true. These are the family-sponsored preference categories, okay? And I'm going to show you in a minute. So let me give you an example. Going to make you think. You ready? Victoria. Victoria is 22. Her mom is a permanent resident, LPR. She's from Mexico. She entered with a visa. If Victoria's mom applies for her, what preference category would she be in? She is the unmarried daughter over 21 of a permanent resident. What does that mean? She's in 2, okay? So hold that thought. I'm gonna make you remember it. Okay, now we're gonna jump to employment-based preference categories. So employment-based preference categories, so let's say I used to work for Indiana University, and we would have faculty and staff. People said, what do you do immigration at IU? I said, we've got lots of it. Faculty, staff, and students, right. Lots of international students. So we would always have issues dealing with that. Students transitioning into the workforce. We had faculty physicians from all over the world, staff workers, IT positions, right? So we would be doing immigration cases for folks that we wanted to keep permanently in the United States. But first we get them an H-1B visa. I'll tell you a little secret, it's not really a secret, but institutions of higher education are not subject to the H-1B cap, which I'll tell you about in a little bit. We can get as many H-1Bs as we want. So you've got so-and-so working for the IT department, right, on an H-1B. Let's say we want to keep him here permanently. So we're going to go through this process, employment-based preference categories. Let's say he is a second preference category because he's got an advanced degree, right? He's got a master's degree, IT guy from India, okay? For example. So we have to go through two things. We got to test the labor market to prove that there's no qualified US worker. This is very interesting. Because people say, well, this is just an excuse to, you know, pay someone less or hire some, or, you know, they're taking jobs from US workers. Well, not in this situation, because we have to go test the labor market. We have to actually advertise for the position at least 6 times, and then the Department of Labor has to certify that we've done everything we can to prove that there's no qualified US worker to fill that position. Okay? Cummins, any corporation has to do the same thing when they want to keep someone here permanently and get them a green card. You have to protect the US worker, right? First. Second thing you have to do is go out and ask the Department of Labor, what is the prevailing wage? What does that mean? It means what's the average wage for the position, in the industry, in the geographical location. So you cannot pay them less than you would pay a US worker, okay? That is where a system exists. If a system exists to do that, then that's what you're held to the standard. Okay, so right now we're gonna show you, I'm gonna show you something called the Visa Bulletin. So the Visa Bulletin comes out every month, and I apologize I don't have the most recent month because we couldn't get the internet to get it, but I have May and it hasn't changed that much. So May of 2018. So people say, okay, isn't there a reason why we have, you know, so many visas per year, right? It's a quota system. The quota system was established many, many years ago, and it comes from our, it's called the INA, Immigration and Nationality Act. If you look here, it says, I don't know if you probably can't read that, it's hard to read, but the annual family-sponsored preference category limit is 226,000. The annual employment-based limit is 140,000, and no one country can get more than 7%. So once you reach 7%, you create a backlog, right? Or if you've exhausted your numbers for the year, you create a backlog, okay? So I want to show you something. So do you remember Victoria? Okay, all right. Good. Victoria, what was she? See, I didn't make these up. These are not fake. They, see, she's F2B, unmarried daughter of a permanent resident, okay? So if Victoria's mom applies for her, remember she's from Mexico, if Victoria's mom applies for her, how long does she have to wait? Well, this is the chart that says what the current processing times are. And if you look here, F2B, from Mexico, they're currently processing cases that were filed in December of 1996. That's my favorite part of the presentation. Because you get like gasps. I cannot make that up. This is not fake. So, okay, how many years does she have to wait for, if she goes through the normal process with her mom to get the visa, how many years does she have to wait? 20 plus years. And even then, because of this wonky thing with because she's an overstay, right? She's not an immediate relative of a US citizen. She never will be, because her mom was a permanent resident. and she's over 21. So this is getting a little bit complicated, but she's going to have to get a waiver because she doesn't qualify as an immediate relative. So not only does she have to wait 22 years, and look, all of them are backlogged. So China, India, Mexico, Philippines are all like backlogged more than any other country because they have more applicants. So let's go back to the employment base. So let's say Cummins, for example. Let's say Cummins wants to get a permanent resident, wants to apply for their person who's an engineer. He's exceptional, he's high skilled, very, very well deserved. He's got all kinds of, accomplishments. And so they apply for him. He happens to be from India, okay? And then they apply for him and he's in second preference category, even if he's in third preference category. Let's see how long Cummins has to wait to get him his green card. They're currently processing cases. Second preference is December of 2008. Third preference is May of 2008. So, what does that mean? So that person is currently here working legally in an H-1B, and they have to extend the H-1B until that visa number becomes available, which is 10 years, let's say, maybe, if it moves with normal time. So the employee has to wait that long, and the employer has to wait that long to get that person a green card. A lot of things happen over a 10-year period, right? So that becomes very, very difficult for some folks to deal with. Okay, those are the preference categories. Any questions? Well, we'll get to those. Okay, slideshow. Oh, uh-oh, we'll get there, hold on. All right, so why can't they just get legal? Now you've seen the backlogs, okay? I'm gonna tell you a story about Victoria. Victoria is a real person. She goes to, oh no, she just graduated from IU Maurer School of Law. She was at IU junior getting straight A's in international affairs when our state legislature decided to outlaw in-state tuition for undocumented students. She had to drop out. She went to Ivy Tech, a couple classes because she couldn't afford anything else. Then our state legislature was very much involved in grandfathering in the kids who had previously been enrolled, and so Victoria got back in school and she graduated from IU Bloomington. Then Victoria got accepted to law school and she graduated from law school. And now she's got a job working at the prosecutor's office in Marion County. Okay, let me tell you a couple of other things. Victoria got DACA, which we're going to talk about in a minute. She got DACA, but another thing happened to Victoria. She also fell in love, and she married a U.S. citizen. And she's an overstay. So what do you know about overstays? Immediate relative? She got her green card based on marriage. So what was once completely undocumented immigrant sitting in my office crying, weeping because she didn't know what her future held for her, is now a very successful lawyer in Indianapolis and has a great story, if nothing else. But so let me see, what is this here? Please don't restart now. Okay. I hate that when your computer restarts and you didn't tell it to. Okay. So EWI, you know that EWIs are ineligible for adjustment of status in the United States. Okay. You know that now. You know about the 3 and 10-year bars for unlawful presence. Can't stay, can't go, can't fix it here, can't fix it there. You know about 9C. 9C is the illegal reentry after prior entry or after prior deportation is a permanent bar with no waiver for 10 years. You know a little bit about the H-1B cap, but let me tell you some more. So the H-1B is for the professional worker, right? Specialty occupation. So a corporation wants to apply for somebody with a bachelor's degree to get an H-1B. We only have 85,000 H-1Bs available per year. And guess how many were submitted last year alone? 236,000 applications. So about 1/3 of the H-1B visas that are requested or applied for are actually selected in a random lottery. So there's no rhyme or reason, at least none that we know of anyway. And you get them back and you say, you have to tell your clients, I had 5 that we applied for in the lottery, and we had to tell 4 out of 5 of them that, sorry, you didn't get selected, we have to try again next year. Luckily, the person has enough time on their OPT, but some people, like our international students, for example, graduate from IUPUC, for example, and they get OPT for a year, and a company wants to get them an H-1B, they don't get selected in the lottery, what happens? Like he said, see ya. They gotta go. Or they gotta quickly get enrolled in a master's degree program, right? Hopefully they have enough money to pay for it. But there are no other options. So they have spent now their college here, paying out-of-state tuition, getting educated in our country on an F1 student visa, but then we don't have an H-1B visa for them. It happens a lot, and they won't get an H-1B visa. So let me tell you one more thing. Before 9/11, Congress would pretty regularly and without much consternation give more H-1Bs. They would issue more H-1Bs if we needed them. After 9/11, not happened ever again. So every year we run out, first year we ran out in 24 hours. Every year we run out within a week. There aren't any H-1Bs right now. So a company doesn't have an option to get an H-1B unless you're a university. And then you can get as many H-1Bs as you want. So, okay. So let's see. What happens if you're in removal proceedings? If you're in removal proceedings, that means deportation, okay? Deportation. If you're, sometimes you might be subject to expedited removal if you have certain criminal history, but if you don't, or if you have a prior removal order, let's say you got deported once and you came back or you never left, then you will be processed for expedited removal because there is an outstanding removal order that can be reinstated, okay? But let's take, so those are kind of exceptions. Any person who gets caught by by ICE rather, if they have not done anything wrong other than being here in the United States and being undocumented, if they have no criminal history, most likely they will have the right to a hearing before an immigration judge. And only an immigration judge can determine whether that person is deportable or whether they merit some kind of relief from removal. There's one called cancellation of removal. If you've been here for 10 years, you've been a person of good moral character, and you have a qualifying family relative that would suffer exceptional and extremely unusual hardship. Now that's different than extreme hardship. I'm serious, it is. So, can't turn yourself in, at least you couldn't before, that I'm not sure about now. If you haven't done anything wrong, probably be released, or you can post bond. You also have a right to an attorney, so people need to know that they still have rights, basic constitutional rights, even if they are undocumented, or if they're on a non-immigrant visa. They have a right to an attorney, a right to a hearing, right to remain silent, right to be free from illegal search and seizure, all of those rights. Backlog for hearing, we are seeing right now that the hearings are being set into 2020, 2021. And so during that time, it's not like if you get caught, they're not going to put you on a bus tomorrow and send you back. You get what's called put in proceedings. Put in proceedings means you get a court date. You get a master calendar date, then you got to go to that, then you got to figure out, then down the road. So there's a process there. It's not automatic unless you're a criminal or you've had a prior removal order. Okay, so lack of immigration status leads to you cannot get a social security number. if you do not have immigration status. Period. Okay? But guess what you can get? An ITIN, an individual tax ID number. What does a tax ID number allow you to do? Pay your taxes. Does a tax ID number give you permission to work in the United States? No, it does not. So what are you paying taxes on? Work that you did illegally, without or with false documents, for example, okay? So you can still get an ITIN and you can still pay your taxes. You cannot get a driver's license or a state ID, period. Decrease access to college. Our state is one of 3 states that restricts in-state tuition for undocumented students. We do have a provision that says DACA students can get professional licensure, which is good. Our state was very progressive in that regard, that one of 8 states that does that. You cannot get state or federal financial aid if you're undocumented or DACA. No state or federal financial aid. Also, limited health care coverage. There's all this talk now about public benefits and restricting immigration to people who have received public benefits. But the funny thing is that undocumented immigrants aren't eligible for public benefits. So if they're receiving public benefits, they are doing it illegally, if they're getting them, or someone's made a mistake or something happened. Because they cannot, by law, you can only get emergency room coverage, you can't get unemployment benefits, and just a host of things. No welfare, no food stamps, all of that. Mixed status families, you heard about Victoria. She's the only person, was the only person in her family that did not have immigration status. Perceived lack of legal remedies, someone who, maybe there's an unscrupulous employer who's not paying a fair wage, but the person's afraid to come forward because they're undocumented, or someone's a victim of a crime and they're afraid to come forward, things like that. And then, last but not least, impact on emotional and mental health. And we see this a lot, especially with students, and the uncertain future of DACA and what they may or may not know. So public benefits and taxes, because this is a hot topic, anyone with a Social Security number does pay taxes and pays into Social Security. It doesn't matter if the number is fake or real. It still goes into the Social Security, and the person, whoever's earnings, will never be eligible to get that back. So that goes in, pays into Social Security. Anyone with an I-10 pays taxes. Anyone who owns property pays property taxes. DACA are working lawfully and paying taxes. And then if you go through a process, any judge or any immigration attorney, usually a process is going to ask you to do an affidavit of support, which says that you've never received public benefits, that you won't receive public benefits in the future, and if you ever do, your sponsor's going to probably be held liable to pay the government back for any of those public benefits. So again, based on my experience, I can tell you with pretty confidently that I'd say in the high 90% of the clients that I have dealt with have paid their taxes. And if they haven't, we have to fix that. Because we don't go to court if we don't have taxes. We don't go to immigration office if we don't have taxes. You don't apply for naturalization to become a US citizen if you haven't paid your taxes. Okay? So that's part of the process. Executive orders are not changes in the law. In fact, this is interesting because you have different presidents have exercised authority about executive orders over the many years. In fact, every president since Eisenhower has exercised some degree of executive authority. The question is, to what degree? Is it permissible? So, for example, President Obama issued the DACA executive order. That was an executive action, which we'll talk about in a second. Another example, President Trump has issued the travel bans. So those are both examples of two different presidents issuing executive orders, which, by the way, are both being litigated, and the courts can't even decide whether the particular president exercised too much or too little authority or whatever. So I would say to you, so if people say, well, I agree with DACA, but I think what the president did was unconstitutional, or whatever, I would not waste time on the unconstitutional question, because the courts can't even decide. The Supreme Court can't even decide. So this is where we talk a little bit about the big P. Do you know what the big P is? Politics. Yes, politics. Politics. Okay, that's just to see if you're paying attention. So politics all the way up. So you've got on both sides. Decisions can't be made. So unfortunately, politics plays a huge role in whether the courts even can determine whether what a president did was constitutional or not. So then you had the travel ban. Again, you had 3 different versions of the travel ban, because the first one didn't hold up in court, the second one didn't hold up in court, the third one's still being litigated. Then you had DACA under Obama. You've got, here's the requirements for DACA are here. DACA is still in effect because the courts have said as much. In fact, interesting, because the expanded DACA and DAPA never went into effect. That was the second Obama DACA thing. That never went into effect because the court said can't do it, unconstitutional. But the previous DACA is in effect and still in effect, and you can still process extensions on DACA. DACA is deferred action for childhood arrivals. By definition, it is for kids who were brought to the United States at a young age through no fault of their own. They're not recent arrivals. In fact, by requirements, you had to enter before the age of 16, and you had to have been here for at least 5 years, going to school, no convictions, and really doing everything that you're supposed to be doing. So DACA in the United States, we have about 800,000 approved in the United States. We have about 10,000 in Indiana right now. DACA gives you 2 years of employment authorization, which means with the employment authorization, you can go get a social security number. And with those 2 things, then you can go get a driver's license. So DACA kids can lawfully work in the United States. They can drive, they can get insurance, they can have identification, all that stuff. And it's renewable currently. What it is prosecutorial discretion to defer removal. We're saying, we know you're here, because you've met these host of criteria, we're not going to deport you, okay? They're lawfully present, but they have no lawful status. That's interesting. That's a fine legal point. So they're here lawfully, but they do not have status. DACA is not a path to permanent residence or U.S. citizenship, and it does not make them eligible for state or federal financial aid, or any public benefits for that matter. DACA rescission, we saw this, that there were threats on both sides. They said, and this is again, the big P, the politics comes into play, okay? So you've got attorneys general on one side saying, we're gonna sue you if you end DACA. Then you have attorneys general on the other side saying, we're gonna sue you if you don't end DACA. Okay, so threat of lawsuits all over the place. And then, so then that led to the rescission of DACA, which again is still being litigated by the courts, okay? Let's see. Future is uncertain. Again, courts, states are challenging the rescission, but over 700 university presidents and chancellors, including our very own from, I believe, IUPUC signed the Pomona College letter supporting DACA students in some degree, some kind of solution for DACA. So watch out for DACA being used as a bargaining chip. You've got DACA became this kind of phenomenon in itself, and all you heard about for a little while was DACA. DACA, 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 we have to get DACA through. Everybody kind of left off all the rest of immigration. Reform was kind of getting left at the wayside, and so people were not really paying attention to the other things, and so they were trying to bring up a bunch of, like dropping the diversity visa lottery program, making changes in H-1B, merit-based, and all this stuff. And so that is kind of past a little bit. We've got other distractions going on right now, frankly, but there are still discussions of changing immigration, and I would just say that DACA is a small part of a very large immigration kind of landscape, that just doing DACA doesn't fix the rest of it. And then you have the impact on workforce. So how do you attract more qualified workers? How do you have global partnerships? And what does the future look like? And how do you create that pipeline? A lot of people have said, well, what do other countries do? And it's my understanding that Canada, I think, is an example that goes and they look at their immigration policies every 2 years or so and say, look at our economy. How's our economy doing? And what do we need, right? How do our numbers, how do our visas and our match up with our workforce needs, right? We've never done that. We've never done that. Our numbers have stayed the same for decades, okay? You saw the visa bulletin. You saw it. That hasn't changed. Those preference categories have not changed. I've been practicing for 15 years. It hasn't changed in probably at least 30, if not more. So we don't change the policies. That's part of the problem. What can you do? Here's some ideas. So beware of fraud. You've probably heard of notario público, a notary. People who are kind of saying that they're qualified to give immigration advice or tax advice, but they're not attorneys. Be careful. Be very, very, very careful. We have seen so many situations where people have been taken, have paid people to do something that they were promised, but it just got them into worse off situation. So make sure you're referring someone to a credible, somebody with a good reputation. If you have a question, call me. We can definitely tell you whether the person is a member of AILA, the American Immigration Lawyers Association, or you can look online. There's an AILA lawyer search there. And then look at some other resources. Be careful. There's so much information out there. Some of the ones that I really like are the National Immigration Forum as a national resource. I think they give excellent kind of tidbits with it's more of like a center, more moderate instead of to the fringe. So that's what I tend to kind of like, that give me everything and I can figure it out kind of thing. I want the facts. I don't want you to hide anything from me. But then you've got local resources too. Here in Columbus, you've got Sucasa Columbus, which is a wonderful organization that I'm very proud to be on the board. Eduardo's here. He's our board chair back here, Eduardo Martinez in the back. And we just look forward to working with the community and growing our relationship with the community. So in closing, before we get to questions, I would say that immigration is complicated. If that's not clear, immigration's complicated, okay? So that is to say, you cannot boil it down to a bumper sticker or a phrase or a commercial or whatever, okay? You can't do that. You guys are too smart. We're all too smart to think that way. So learn and draw your conclusions. If you think DACA's okay, but you need to learn about, it's okay to say, well, I kind of like that, but I'm not sure about that. That's okay. That's critical thinking. Critical thinking. And that's what we need to do with an issue like this. You can't just say, let's deport them all, or amnesty. It's not like that. I mean, I can't like put people in corners, put them on the far right or the far left. The issue is so much more complicated than that. So with that, I will open it up to questions.
First, let's say thanks to
Can I tell one more story? Yeah. So Myra here, I forgot I had her. Myra is my client, was my client. She, most recently, this is an example of what's happening right now. The priorities have changed. We've seen an uptick in removal, an uptick in detentions. Myra had no criminal history. She has 2 U.S. citizen children. She has a U.S. citizen husband. Yet she was detained by ICE for 5 months because she applied for DACA. Because she wasn't eligible because she had a prior removal order. They would not release her. Another thing about Myra is she's a 9C. Remember 9C? She had a prior removal, then she re-entered after a prior removal order. And so people say, well, she has a U.S. citizen husband. Why couldn't that fix things? No, we had to go to court and we had to prove that if she went back to her country, Mexico, that she would be subject to persecution because her family has been threatened by the Zeta cartel and they've had to pay them off to be safe. And so this is an example of a very specialized case where somebody who shouldn't have applied for DACA got her detained because someone made a bad decision or gave her bad advice. Okay? But there's a happy ending, thank goodness, that we won the case. But it's an example of all of these complicating things playing into a situation. So.
I'm going to ask the first question, but in the meantime, if you have a card, write a question down for Angela, and then we'll have you hold it up, and members of the church will grab them, and then bring them forward, and I'll look through them and make sure that we can ask her some questions. Angela, first of all, thank you so much. I wonder if you can explain from a legal perspective what is happening right now. Attorney General has said that Jeff Sessions has said that now we have this the zero tolerance at the border, and it seems like people who are getting detained are going through something much harsher that they were going through prior to whatever this policy is. Can you explain what that is all about, that zero tolerance?
Yes. So the zero tolerance is new, okay? The zero tolerance did not exist prior to the Trump administration or prior to Sessions implementing it. You may have heard, though, under President Obama, he was nicknamed Deporter-in-Chief many times because there were so many deportations, record number of deportations. But the difference was there were priorities. Priorities meaning they set priorities based upon their resources. And so they would say, well, we're going to go after the criminals, we're going to go after the drug dealers, we're going to go after the terrorists, the threats to national security first. Even though they're harder to find, we're going to find them. Now, they're not going after, they're not prioritizing. Anybody is fair game. And so I have changed my advice. When I talk to my clients, I advise them if you get a denial on a case, if you fall out of status, you are in danger, that you may get picked up and you may get put into proceedings. It doesn't matter if you're a criminal or not, or if you're doing anything wrong. So the zero tolerance means anybody is fair game. And and it's the easy targets now, because they're easy targets. So there's a difference in the way that the law is being enforced. And on the border, you see what we saw too with the child separation. That was also a new policy. Children had not previously been separated from their parents. And that was a new policy. And then so what happened was they were also trying to get them, this is also from experience because I have a very dear friend who actually volunteered on the border and went down there and spent a week down there. And they were giving people an option to say, sign here if you want to get your kids back, but you're waiving all your rights so that you can't seek asylum or anything else. That way you can see your kids. Or sign here if you want your kids to stay with you, stay here, and you leave. That was the only option. I actually saw this piece of paper. Those are the only two options. It wasn't if you're eligible for asylum, because they weren't giving people the what's called a credible fear interview. The credible fear interview is like, in law school, it's called prima facie, right? You make your face case. So you have first step is your prima facie, and then you get to a judge and give them the merits, right? So this is like credible fear is the first step. They weren't allowing people to have a credible fear interview. And so they weren't even giving them an opportunity to apply for asylum for cases that would have otherwise been vetted for asylum. And Sessions even went a step further to say that people who have been the victim of gang or domestic violence no longer qualify for asylum. Well, this is like case law, right? You're just all of a sudden making law. I mean, you're just all of a sudden like dictating law without even going. So there was a case, and then he overturned the case. So there is a case out there that says you can't. But so you never could get it just on the basis of, like if you came to my office and said, I've been the victim of gang violence or I've been the victim of domestic violence in my country, that doesn't qualify for asylum. But what does qualify for asylum is if the government is unable or unwilling to control the gang, or the domestic violence has become so prevalent that it's more of a social group issue. So you can't, that's like long-standing law. That's what was going on.
If you have questions, raise the cards, and they'll get picked up, and then I'll get to them. While they come, so Angela, if I give a ride to the doctor to an undocumented immigrant, am I in trouble with the law?
No. So there's two things there. There's something called aiding and abetting. You may worry that or harboring is the other one. Usually social service organizations or people that work for churches or lawyers in our state law and in the federal law are exempt from that kind of violation. And the other thing is you're not assisting anyone in committing a crime, because if you remember, someone who's just simply being here, undocumented, is not committing a crime. But if you're doing some kind of act, you're like doing something to conceal them or hide them, or then there's this other hot button, sanctuary, right? We've heard of sanctuary cities or sanctuary campuses or what, right? So that has been another hot button issue. But in and of itself, you should not be doing anything wrong if you're giving a ride to someone who's going to the doctor. Now, if you're employing someone who's undocumented, that's a different story. It depends on if you knew and how you knew and whether you did all of the appropriate documents, right? And whether you did your due diligence, right? You don't have to be an ICE officer. You don't have to know whether the documents are real on their face, but you need to do the I-9 and you need to make sure that you've got a file to back it up.
Tell us again where the visa bulletin is available.
www.travel.state.gov, and you can just...
One more time.
www.travel.state.gov, G-O-V, and it comes out every month, and I just put a little search and I put current month, September 2018 visa bulletin, and it'll pop up on the list.
Can a person with an H-1B visa, while in process of permanent residency based upon employment, can they leave and re-enter the U.S., or are they stuck here while they are in process?
No. Yes. So, no and yes.
All right, next question.
No! Yes, they can leave. They are not stuck here during the whole process. That's a great question. H-1B allows for dual intent, so you can be pursuing a green card at the same time that you're on an H-1B. That's okay. It's one of the few that does allow for immigrant intent. So as long as your H-1B is valid, you can leave the country and come back with the H-1B, the underlying H-1B, or you could get a travel document based upon your pending adjustment application.
How do our immigration laws and practices compare to European countries, to Canada, to Japan, to Australia?
Next. Just kidding. I don't know, because I think that's a great law review question. I only practice immigration law in the United States. I honestly have never gotten into the complexities of other countries' immigration policies, but believe me, I know that they exist, and some of them are probably less adequate, and some of them are probably more adequate, and we could probably learn from countries like Australia and New Zealand and some, Canada or others. I know that there are immigration processes, and they're not easy, and not that they should be easy, but I don't know the ins and outs of all of them.
You may decline to answer this question if you want. There are rumors that Indiana legislature will take up in-state tuition in next session. Mm-hmm. Have you heard anything of that?
Yes,
okay.
Representative, oh my God, Earl. What's his last name? Okay, I'll think of it in a minute. Anyway, yes, he's going to propose that, but it's come up every year for the last, since 2013, and it's never gone anywhere because it's usually proposed by a Democrat, and the Republicans don't want to hear that, and so it's again, the politics is an issue, so unless we find a Republican champion to take it through, then I don't know what's going to happen. We'll see. But DACA kids can get in-state tuition. So DACA kids are eligible for in-state tuition because they're lawfully present. It's undocumented, those who do not qualify for DACA, that cannot pay in-state tuition.